For years, the U.S. Post Office has been one of the few places in America where a law-abiding gun owner instantly becomes a potential criminal the moment they walk through the door. But that toxic reality began to change in September 2025. A federal judge has just torn a massive, gaping hole in the government's gun-free zone fortress, and the fallout hit the Postal Service so hard that they were forced to quietly tell their own employees, if a customer is armed, leave them alone. And here is the part no one is talking about. While the USPS is frantically scrambling to rewrite its enforcement rules, the Department of Justice, DOJ, is already trying to violently shove this genie back into the bottle before this historic ruling spreads nationwide. I am breaking down exactly what changed, why it changed, and why this moment could unilaterally redefine where Americans can carry and how much power the government truly has to dictate where your constitutional rights begin and end. For most concealed carry holders, the post office has always felt like that one weird, necessary stop on your daily route where the rules of liberty suddenly flip backward. You can carry lawfully in the grocery store, at the gas pump, maybe even walking your kids into church. But the very moment you turn into the post office parking lot, you feel that urgent, cold warning in the back of your mind. If I mess this up, it's not just a ticket, it's federal. That fear did not emerge from nowhere. It was a condition engineered for years by the state. Washington aggressively built a punitive legal bubble around these buildings. A federal statute, 18 U.S.C. Parf 930A, made it a crime to possess a firearm in a federal facility where government employees work. A separate internal USPS rule, 39 CFR, Parf 232.1L, then illegally stretched that idea to cover almost everything with a blue eagle on it. The lobby where you buy stamps, the sidewalk leading to the door, the customer parking lot, even the basic blue drop box on the corner. On paper, this system transformed the post office from just another errand stop into a miniature, unassailable weapons-free zone. The result was simple and highly effective. Most concealed carriers did not need a lawyer to spell out the risk. They saw the signs, they heard the stories, and they instantly understood the catastrophic stakes. Walk in armed, and you might become a federal test case. Walk in disarmed, and you are legally safe, but physically vulnerable. So, trip after trip, people who trust themselves to carry everywhere else in town quietly unloaded, locked the gun in the car, and desperately hoped nothing bad happened in the 5 minutes they were standing in line. From a constitutional standpoint, that matters profoundly. The Second Amendment does not say, shall not be infringed except when you're buying a money order. When the federal government draws bright red circles around ordinary, everyday public spaces, not courthouses, not polling places, but basic service buildings, and declares your core right-off limits inside that circle, it is not just managing security. It is actively rewriting in practice where your freedoms actually exist. And that is exactly the system the historic Texas case finally dragged into the blinding spotlight. The crucial tectonic turning point in this whole story did not happen in a backroom committee in D.C. It happened in a federal courtroom in Texas. In September 2025, two ordinary Texans, aggressively backed by the Second Amendment Foundation, SAF, and the Firearms Policy Coalition, FPC, walked into the Northern District of Texas and essentially said, "Enough. You do not get to erase the Second Amendment every time we step into a post office." Their argument was simple but lethal to the government's entire position. After the Supreme Court's triad of Heller, McDonald, and Bruen, the rules have been permanently changed. The Supreme Court has already confirmed the right to carry a handgun for self-defense is a protected liberty. Bruen then mandated a second, non-negotiable layer. If the government wants to ban carry in a particular place, it must prove there is a real historical tradition of similar bans dating back to the founding era, not just a modern political feeling that guns make us nervous. Judge Reed O'Connor took that framework with the utmost seriousness. Step 1. Does the Second Amendment's plain text cover what these plaintiffs are doing? Yes, they are carrying handguns for self-defense. That is the heart of bearing arms. Therefore, the burden immediately shifts to the state. Step 2. Can the federal government demonstrate a long, consistent historical tradition of banning ordinary, law-abiding citizens from carrying firearms in places like standalone post offices? That is where the entire case collapsed for the Department of Justice. They pointed to a handful of more recent rules about weapons in general government buildings, but they could point to 0 founding-era laws that treated everyday postal buildings as off-limits zones for armed citizens. They also tried to cynically slap the sensitive place label on post offices, the same label appropriately used for courthouses and polling locations. O'Connor firmly rejected this attempt. A small-town post office where people run in to grab packages and buy stamps is not the same thing as a courthouse full of judges and juries, or a polling place where elections are being conducted. So he drew a clear, unambiguous line. In an ordinary post office, the kind you drive past every day with a flagpole, a customer parking lot, and a public lobby, the federal government cannot simply declare that every law-abiding citizen must be disarmed just to stand in line. Applying the postal weapons rule and the federal facility statute to people like these plaintiffs in that setting violates the Second Amendment. But he did not stop at mere words. Judge O'Connor issued a declaratory judgment and a permanent injunction. In plain, actionable English, that means he did not just say, "This is wrong." He ordered the government to stop enforcing those rules against the named plaintiffs and similarly situated SAF and FPC members when they carry for lawful purposes in ordinary post offices and the connected customer areas. For those people, the post office is no longer a legal trap. It is just another public place where their right to self-defense still follows them through the door, exactly as the Constitution intended. A federal court order on paper is one thing. The way a massive, ossified bureaucracy reacts is an entirely different, more critical issue. Shortly after Judge O'Connor's decision, an internal USPS memo surfaced and was later authenticated. It was addressed to postal retail employees and supervisors, and its explicit purpose was practical, to tell frontline staff how to respond when a customer shows up armed. The memo makes a stunning, critical admission right up front. It states that a federal court order currently permits certain postal customers to carry and possess firearms at most post offices, including in customer parking lots. That is a remarkable institutional surrender to read in an official USPS communication. For decades, the institutional line has been simple: no guns on postal property, ever. Now the agency is officially acknowledging, at least internally, that this is no longer true. From there, the guidance is two-track. First, retail employees are strictly told not to confront or engage the customer about the firearm. They are explicitly instructed to let the person conduct their business in the same manner as other customers. That means no impromptu policy lectures at the counter, no demands to disarm, and no immediate calls to the police just because a gun is present. Second, once the customer leaves, employees must report the incident to a supervisor or manager. Management, in turn, is told to contact the U.S. Postal Inspection Service hotline. The inspection service will decide whether the firearms ban can lawfully be enforced under the specific circumstances and whether any further action is justified. The memo also draws a clear, necessary line on involving local law enforcement. It says that 911 should only be called if the customer is interfering with operations or acting in a way that raises immediate safety or security concerns. In other words, simple possession of a firearm without threats, disorder, or criminal behavior should not trigger a police response. That is a quiet but deeply meaningful shift away from the old, dangerous assumption that an armed citizen on postal property is automatically a problem to be removed. At the same time, the memo tragically underscores that nothing has changed for employees. It explicitly reminds postal workers that the court's decision does not affect the ban on firearms possession by Postal Service employees on postal property. Carrying or storing firearms on postal premises, including in personal vehicles parked there, remains prohibited and can result in severe discipline up to termination. So even as USPS adjusts its treatment of some armed customers, it keeps its own workforce completely disarmed on the job regardless of local carry laws. Predictably, the Department of Justice did not treat this ruling as a broad defeat. Instead of taking the case straight to the appellate court to reverse the ruling, DOJ lawyers chose a more cautious and strategic countermove. They asked the judge to clarify the injunction. In practice, that request is purely about limiting how far this decision can reach. Their argument relies on the critical distinction between an as-applied challenge and a full facial strikedown. Judge O'Connor did not erase the federal rules entirely. He ruled that when applied to law-abiding citizens carrying for self-defense in ordinary post offices, the government could not justify those restrictions under Bruen. The DOJ is now using that narrow framing to desperately insist that the injunction should apply only to the specific plaintiffs in the case and to verified members of SAF and FPC, rather than to every gun owner who walks onto postal property. Viewed strategically, this tells us a lot about how the federal government perceives the post-Bruen legal landscape. Agencies like USPS and prosecutors at the DOJ understand that Bruen has made it exponentially harder to defend sweeping gun-free zones. Courts now expect real historical support, not mere assumptions or modern concerns. So the government is desperately trying to contain each loss, accepting narrow defeats while keeping the broader enforcement framework intact for everyone else. In practical terms, that means the federal restrictions are still technically on the books. Outside the specific group protected by the injunction, postal inspectors and U.S. attorneys can still bring charges, and courts in other regions are not required to follow Judge O'Connor's reasoning. For most gun owners, that remains a real, unacceptable legal risk. But there is a far more important side to this moment. This case proves that Bruen is not symbolic. It is actively shaping real policy. When gun owners challenge overbroad restrictions with solid legal backing from groups like SAF and FPC, they can force federal agencies to rethink long-standing unconstitutional assumptions about where the Second Amendment applies. And the fight isn't limited to carrying inside post offices. Separate lawsuits are challenging the federal ban on mailing concealable handguns through USPS, a restriction dating back to the 1920s. Other district courts have questioned whether federal weapons rules can be applied to postal workers at all. Piece by piece, these cases highlight USPS as a significant battleground in the broader question of whether the federal government can carve out large, everyday public spaces where constitutional rights are treated as optional. Ultimately, the significance of this Texas ruling is not about creating a new right. It is about restoring an old fundamental one. It signals that the government cannot permanently wall off ordinary publicly accessible places from a fundamental liberty simply because it is administratively or politically convenient. And for millions of Americans who carry to protect their families, it powerfully reinforces a simple point. The courts are finally beginning to say out loud, the Constitution doesn't stop at the edge of the post office parking lot. So, what should a responsible gun owner do with this information? First, be absolutely clear about where you stand. If you are a member of SAF or FPC and your situation clearly matches the one described in Judge O'Connor's injunction, your legal risk when carrying in an ordinary post office has fundamentally changed. The federal government has been directly ordered that it may not prosecute you simply for being armed while you conduct postal business. If you are not in that category, the prudent course remains caution until higher appellate courts weigh in or Congress changes the law. 18 U.S.C. paragraph 930A and 39 CFR paragraph 232.1L exist and provide prosecutors with tools they can choose to use. No commentator can guarantee how a U.S. attorney or postal inspector will react in your specific district. When in doubt, consult with competent local counsel and make conservative choices that proactively protect your liberty and your ability to own firearms. Finally, always remember that these hard-won gains did not appear by magic. They are the direct result of years of costly, grinding litigation supported by ordinary citizens. Staying informed, backing effective organizations, and carrying yourself as a disciplined ambassador for the right to keep and bear arms are all part of the essential work. Thanks for watching. If you found this breakdown useful, stay with me. Every week, I'm working to bring clearer research and stronger analysis. And if you'd like to support the grind, even a cup of coffee helps keep these videos coming. See you at the next one.